Kihara Martin ndirarehe ndumiriri ya macakaya kuma family yakwa ya Kagiri na entire mugunda handu hothe haruma na Mutito Water Project member 6,000 njuge uyu ni wakini wakwa tureranitio nake na kahinda karia twaikaraga nake thiini wa matura maya titwakurire ota twana turia tungi na maundu maria mekagwo ni mwana nini nitwekire nake haswa hingo yo guku kwari Mutito nitwahitaga thwariga nake na nitwakurire o hamwe na tukihana riria twagimarire andu magithie gwetha indo miena na miena na riria Kihara wa Gathua wakini wakwa athire thiini wa media house na nie ngithie kuria ndutaga wira nitwakirire tukiaranagiria na tukigeragia gucokia makinya maitu na mucii na njuge nidirenda kuoya kahinda gaka tondu ndaigua ni ahetwo ngoga handu hothe Kenya ya ruma haswa thiini wa media house gikanitha na family no wega njuge thiini wa itura riri ndiraigua agwetetwo na kina uria kwagiriire tondu ndirona ta ingigoca ritwa riake in a big way njuge Kihara wa Gathua nie nindageire na mugeni wendaga guka thiini wa itura riri murata wakwa kuma kuria United States of America na ni mundu wari popular sister ya Obama ni murata wakwa na no mundu mwenderire ati ni aroka tondu ni undu weritwo uigwo na thiri nene muno tondu ari a public figure Kihara riria ndamumenyithirie anjerire ndakuga indo maundu macio tondu okaga tugerie kuona ni ate tungikira community no itu no Kihara ari muruna wakwa ari wakini wakwa ndaigire thiri iyo no ni disclosure undu ucio kuri media na media igikinya mbere ya mugeni ucio akinye through Kihara nitwageririe na nitwathondekire cukuru wa mugaka tondu undu ucio ni au breakire thiini wa media tugicoka tugiaka cukuru haha na nitutwaranite nake wega na niturathie arake break thiini wa record tugiaka thibitari wa mugunda thank you very much niwe watigwo kuu kungi icio ingi urikie
iratigwo eni tondu niguo kwagiriire bas hep hep.
Bwana asifiwe. Basi kwa niaba ya hii timu yote ambayo ni wafanyikazi pamoja na Lucy, tumekuja hapa kwa niaba ya wale pia tumewaacha, kwa niaba ya director wetu ambaye ni wa Ulinzi Sports Complex. Tumekuja kusema pole kwa familia na kwa jamii yote, kwa majirani na kwa marafiki wote wa mwenda zake. Sisi tulichelewa kufika hapa, tunawaomba radhi. Tunaomba pia mpokee hizo pole zetu na pole za director because ametutuma na mtaturuhusu pia tutaondoka kwa sababu ya masaa na tunawaachia tu pole zetu. Mungu awe pamoja naye. Asante.
Asanteni sana, hawa ni wanajeshi. Asanteni sana. You can now take your seats. Eish. Tuditero wega.
Bas na ni wega. Tugithie kurikiriria nigetha tutigie atongoria me haha wabici ya senator eguku no tumirwo Jackie ekuo gotire weko Jackie ndari kuo Jackie onake ndari kuo bas na tondu matire kuo tutikurugamia maundu maitu bwana kokoriko okaha munene wakwa nigetha ukigeithia andu aya na andu aya ni makumicaga muno
Ngai ni mwega hindi ciothe aija kandu mahutire githinji kokoriko muratae wa family ino
na makiria muratawe wa Martin Kihara Gathua miaka iria Kihara arutite wira kuria Nairobi akoretwo murata wakwa tutanahikania tugakorwo tukinyitanira maundu tugukaga umuthi kunyitanira na family tondu through Kihara family ni matwikire arata itu Wanjiko akahiu na acio angi turehera birabi kuma kuri family citu tondu ni family twatwikire family friends turehe rabirabi citu kuma kuri andu aria turarutaga wira nao ni atunyitithanirie na andu a media na andu aria angi kinya rira twethaga iti Ngai ni atutaithitie tugakorwo tutari githagatho-ini giki gikuo no kiu kingi mukurino ndenda kuneka meme gaka umere tugakorwo kuo na Ngai amurathi.
Aya, yes, thank you muno Kokoriko. Yes, na ni wega oguo. No aguku. Amen.
Fathers, family, ciere cia Kihara wa Gathua, ithe wa Kihara, brothers and sisters, andu aria mokire ni undu wa kugia na wendo wa Kihara, umuthi tutikwaria maundu tondu mathaa ni mathirire, ona ngugite andu aria metagwo ateti toni ndire muteti tutige kwaria, no njikai uguo. Ngai ni mwega na hindi ciothe. Niĩ ngwenda kuga tumĩrĩrie family ya Kihara, tumere manyitane, atumia erĩ ake manyitane, marere ciana tondu riria macaririo ni Kihara wa Gathua amacaririe nigetha magie na ciana, na tondu riu ni mwatigirwo ciana ngumuria munyitane. Ni ndaigua ciamani akigweta ha maundu maria horo wa ciana. Family ino yanyu ni nini, Wanjiko wagirire gwiciria uri ogutwita turore horo wa ciana icio guthoma tondu kindu kia bata ni ciana icio Kihara wa Gathua tiga maya mange no twarie maguku thi no korwo ndwarerirwo Wanjiko na Kihara agikunyitirira oguo ndungikinyite oguo hana. Nie ndireciria oguo ciama na komiti o yuma tondu andu no maremwo ni gwika undu utwite tuikare twi hamwe turore horo wa family icio family ya Gathua. Nie ngwenda kurikia njuge inyuothe ndimuhoe na gitio. Ni murona maundu uria mahana, maundu makarituha, tukona gatari nduma iyurire na yaiyura. No ngoria atiri nie kiria ndiroria. Nie ndiroria Rigathi wa Gachagua aheo justice in court. Full stop. Staki mambo ingine. Na tuurie tondu
the law did not allow that person to do that. So that, my Lord, all these cases we are aware of. So that, my Lord, as far as Article 165 is concerned, we submit that that is not possible. But, my Lord, this argument is developed a little bit further by the petitioners' applicants. Because the petitioners' applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do two things. One, to sit at night to appoint a bench and to authorize that bench that sat on Saturday to conduct their business on Saturday. But those are irregular because, as we are saying, when this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside the on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, agreed. We still do not know them. And if we do not know them, every Kenyan who would be aggrieved by a decision made in these circumstances would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My Lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to undermine the Constitution and to defeat it in a manner that would amount to treason. So that, my Lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the Constitution and something that would amount to violations of the Penal Code as far as the issue of observing justice is concerned. My Lord, for argument's sake, we proceed to make that argument. Let's assume that there was an emergency. We submit there was none, but let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast-track that hearing. But, my Lord, what is it that happened? My Lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the Constitution may be completed. My Lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the Constitution that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan Constitution. By your oath of office, your lordships are committed to stop a respondent and a government and its appendages that act in this manner. My Lord, what does it amount in law for the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me? I'm here today for this matter, and I'm here because there is a constitution in Kenya. My Lord, that being the case, there has to be satisfaction. If the Chief Justice, and she's a party in this application, cannot be able to justify why did you choose to address the grievances of the Attorney General and the government of Kenya and leave the petitioners. The first right of hearing under our Constitution, I deal with Mutunga rules every day, is that the petitioner will have their rights to be heard, to prosecute their case. That is what the Bill of Rights means. The respondent, even under Mutunga rules, will respond and answer allegations that have been made. But, my Lord, where the Deputy Chief Justice chooses to fast-track the grievances of the alleged violator, common sense has to be affected. My Lord, the conscience of this court must be bothered. Such conduct, in the normal sense of things, we went through the removal of judges during those days. There was just minor infractions of the right to be heard, and judges were shown the door home. But, my Lord, here, it is a systematic decision consciously made that would have very harmful effect for the jurisprudence of our country and for the meaning of our Constitution. So that, my Lord, so that my learned friends can be able to speak for themselves, we are alleging that as long as the bench has been appointed by the Chief Justice, who has declined to follow the fair process for purposes of appointment of the various judges to see, there cannot be a valid appointment. Not because I and my colleagues here would have anything on a good day before any of you, Your Lordship. We have done very many matters. You have courageously stand up for the constitutions in various matters, but my Lord, unhappily, we have to be the ones saying that it would appear to a section half of this country, if not 3/4, that you have been enlisted in service of the violations of the constitutions. My Lord, that may not have happened, but that is the only way reasonable people would be able to interpret all this, particularly against the background that even the Gen Z were abducted. The substantive Chief Justice did not empanel a single bench to sit on Saturday or on Sunday. That is why this was the context in which this matter must be viewed. My Lord, there are certain authorities. My Lord, colleagues will go through them. But I need to mention at least two things. My Lord, of course, the arguments would be made. I think there was some time back, probably in the Okio Mtata case, my learned colleague will clarify, where the Deputy Chief Justice, the same Deputy Chief Justice, made an appointment. There was no substantive Chief Justice at that time. There was a decision that was saying, this is administrative. That decision is not binding. But my Lord, more importantly, now that this issue is arising directly, this court must retire, make a very reasoned decision to settle this issue. Whether in every other case in which the constitution or statute says so and so will do this, if that so and so does not do it, without failure, the High Courts and the Court of Appeal have always held there was no jurisdiction. An order of certiorari have always issued. It shouldn't be different in this particular matter, because the power belongs to the Chief Justice. Now, the second issue is a decision, I believe, one of you was involved, and which is that case? I believe it is a case of Okoicho Mkata versus JSC, and the decision in that decision was that at paragraph 29 to 38, basically it says that where there is a substantive Chief Justice who is a state officer, she does not cease to be a Chief Justice in this era of technology. And accordingly, the Chief Justice, the CJ, does not have authority under the constitutions to assign roles assigned to that office. So that, my Lord, in this case, even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough, because wherever that the good Chief Justice might be, this is something that she could have done as expected her. And the people of Kenya obviously would be interested because of the nature of this matter. Why would the Chief Justice abdicate to do her job and let her deputy to do her job in a manner that aggrieves the petitioners? That is an important question, because it is the job of the Chief Justice. There is a huge mandate that is given by the Chief Justice. Do your job with the entire authority that your office carries. So it cannot just be that it is for the Deputy Chief Justice who has usurped. It is also abdication. What would be the basis for abdication? The Chief Justice not to do their job. The other case of, just 1 minute, 1 second. The other case